No more hidden verdicts, no more secrets solved. Every voice is a weapon, every story be told. Innocent till proven guilty, that's our final decree. Under this constitution we stand forever free. Phoenix in the dawn, truth ignites the sky. Together we stand tall, no more asking why.
Phoenix here, and we're no longer asking why, because this new breaking redacted court minutes that were in a closed session with the IDAHO4 is been unsealed. Guys, we get to see it, and we're going to look at it together right now. But first, I want to state this. This is my humble opinion. You see my banner across the bottom. We're not here to accuse, defame, slander anyone, or harm the reputation of any person, entity. All individuals are presumed innocent. Innocent until proven guilty in the court of law. Do your own research. I always say that. But I'm bringing you the facts and the evidence in this case with State of Idaho v. Koberger. Let's look at the document. So here we have, on June 18, 2025, just weeks before the plea deal agreement with Koberger and the state of Idaho, we have a hearing. The first part of this hearing was streamed. It's on my YT. You can go and take a look at that. It's 6/18/2025. It was public. And then they cut it off and say the rest of this hearing is going to be sealed, quiet, hushed, hidden, not seen for the public. Until today, we get to see it. And this is what they knew that we didn't know back on June 18th. So let's look at it. It says the court resumes. The judge says we're here for the alternate perpetrator agreement. Basically, got to clean some house and do some stuff. And the defense says, well, we've submitted everything. I don't think there's anything else to submit. Does the court have any specific questions? Judge says, nope, don't have any questions. And then the counsel for the state's position. If they don't have a problem with us confronting this evidence, then great. We'll do it. We'll do it step by step. And the judge says, let's find out what the state's position is. So then Mr. Thompson gets up and says, I think we may be dealing with a bit of an issue of semantics. State views alternative perpetrator evidence as being a very defined category. Oh, yes, Mr. Thompson, we're going to find out, because I'm going to show you the next document. But let's get through this one. The defendant will argue that he didn't do it, and this particular person did it. Well, we already know his DNA wasn't in or on Maddie Mogen. We know that by an independent, third party, highly qualified DNA lab. We know that. And if he says, well, I didn't do it, well, he didn't unalive or kill Maddie Mogen like we were told. And if he wasn't there to do that, did he commit burglary? Did he plead guilty to something he's innocent for? I believe so, but I digress. So the defense says we don't have factual basis to make that kind of argument. They basically say they do, and I'm going to show you why, because another document was unsealed when I started making this video. Then they say they have provided general information that they might ask investigators about to deal with the scope of the investigation, but not to the point of justifying their point to point to a particular person, saying that it's an alternative perpetrator. Well, I'm trying to hold my breath here. Looking at the defendant's most recent filing, the response to state's objection, there is mention about the defense's theory that might be more than one perpetrator. Yeah, it's not alternative perpetrator evidence. That's what the state is saying. They are welcome to cross-examine the scope and quality of the investigation, but they should be directed that they cannot focus or direct the jury to say this other person or this other person is the person who committed these crimes. Whoa. Okay, I'm going to hold my breath. I'm going to hold it. Then the counsel says for the defense, I want to clarify two reasons that there was a statement about there could be more. One being that we've not looked at all the tip evidence, and it's coming in still, which is a ginormous amount. We wouldn't want to surprise you. We know you don't like surprises, Mr. Thompson, But when it comes to the other thing regarding numbers beyond 4, I think that the court has seen in the exhibits the number of people who have been examined for DNA. There are some people whose DNA was extracted and comparisons were made, and there's a whole other group that are on those states' exhibits where DNA samples were taken, but they were never developed into an extraction for comparison purposes. I've been saying that all along. Also, names I think we know if they develop over the course of the case and people are coming in, whether it's just in the form of initials for the person or the form of names, or putting these people that have listed on the stand. It's very clear that what the arguments, the names are. We have a discussion and what's fair games and closing argument. I think we'll leave it at that. Oh, and then Mr. Thompson, what Mrs. Mastoff just said is exactly what we're concerned about, Your Honor, and why we ask the court direct that they make an appropriate proffer to justify whoever they want to claim as an alternative perpetrator. To take the position if they developed during trial defeats the entire purpose of the motion in limine and leaves it wide open and just subject to attack or ambush during the course of the trial. You mean getting somebody up on the stand to confess? In my humble opinion, probably. We believe that's not appropriate. Well, isn't a clean and thorough investigation appropriate before you charge somebody with a heinous crime? That's just a side note. Well, the judge goes and tells them, obviously, yada, 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 you could read this. And he says, I suppose during trial, if somebody confesses, that's a different situation. I'm not holding out hope or belief that's what's going to happen, but I suppose you never know. I want to be clear. I will issue a ruling, but I'm going to tell you that I don't find the defense has submitted anywhere near sufficient evidence to get beyond rank speculation that these individuals were in any way involved with this crime. Heavily redacted, because they're not going to tell us. But this is nowhere near trying them to the crime itself. Okay? The reason I want to have this hearing and the reason I wanted to sealed is because I'm not inclined to allow counsel to go out and destroy reputations of people without any foundation to do so. Before there is a suggestion to the jury and specific named individual was involved in this case, I better hear about it first. The defense is entitled to cross-examine, but the scope of the state's investigation and thoroughness of the investigation and the reasonableness of the investigation. Y'all, this investigation was crap in the beginning, and it is still crap. Certainly questions, that was my humble opinion. Certainly questions may potentially come out about why didn't you do this and why did you do that from the officers. Where we might get more tenuous is when we start getting into collateral information about individuals. I can understand that a claimed motive might be as important as it relates to the reasonableness of the investigation. Provides examples. I want to be careful that if it is offered at all. And then, not more than just a few minutes into the closed hearing, everything gets redacted. Still no transparency to the public. None. N-O-N-E. None. None, none, none. And then they want to know, okay, well, who got the summons? Who's going to be at the witness? Who's going to be? I'm going to show you. So basically, ISP started calling people in June of 2025. They wanted to know who was going to be present in court. So-and-so has not received a subpoena. He has not had any contact with the defense. She received a subpoena, yada, yada, yada. This is supplement 207. You can find on Justice for All website, which I will add in here so that you can see. And it goes on, and they kept asking people that, wait, they hopefully knew, but why is the state police following up to see if these people were coming to court, if they got a subpoena or not? ISP was only in assisting this case. So why does the state police now following up with these individuals? Were they hoping that they were going to come to court? Some people hadn't got subpoenas. Some people changed their number and not an active phone number, and no contact was made. And then contacted the Moscow Police Department. Officer Andrew Fox had contacted blankety blank on May 29th, 2025. He has received a subpoena. But he's had no contact with the defense. So some people had, some people haven't. And that's why they wanted to know who was going to be ending up in court. So then we go back to the hidden court minutes before they pause and end the hearing. And Ann Taylor says something very interesting to me, because the state does not have any objection to what the court has outlined, shares concerns regarding witnesses. And then they talk about who's going to be permitted, photograph, victims, jurors, whatever. And then Taylor says, well, we have witnesses who would not be classified as victims. They're vulnerable. I don't know who she was going to call. We'll find out probably eventually, hopefully. And she said, aside from what I want to weigh in a little bit on the media pulled camera, the media has access to the courtroom. When we started to the court, could review some of the issues that we had. That's why the court's live stream started. Okay. So, stepping away from that, then he says, basically, I can't tell him what to use or take any photographs that might show counsel's work. If it were to do so, it would be included in things they can't do. All right. So, I mean, they're just talking about some housekeeping, right, with the media. And then they go into the jurors' questions, which is very interesting, because if you were on my live this morning, I talked about the key to special attorney generals that were mentioned in question 55 on the questionnaire. Highly interesting, to say the least. So they go on to say this, but then obviously they're talking about the jury and members. And Anne basically throws this out there that, we'll be as efficient as we can, which is, honorable. And then they said, basically, Anne wants to make sure to include both possibilities instead of only the death penalty. Well, those I went over this morning in the live too, which were very interesting. They wanted to kind of get the jurors' feel, if they opposed or agreed with the death penalty, and that if they didn't warrant finding him guilty, then maybe life, right? Or if he wasn't guilty. So those were some interesting options. And then the judge responds, Judge Hippler says, what we're trying to find out is if they have an attitude about the death penalty, not necessarily about life without parole. I haven't heard that's something we have to specifically ask about. I could be wrong. Well, Anne wanted to make sure this got on the questionnaire, because if you were watching the Karen Reed trial, this was huge at the end of the jury making their decision. She wanted to avoid something like this. And then Anne responds to, kind of the other side of the same coin, essentially. And the judge says, if you see something you want to add, you can certainly propose it and I will look at it. That's it. That's it. That's how much power. That's how much power our courts have over people. When you are roped into a system that we see on display in real life right now. It's wild, guys. It's wild. But let me bring you something else real quick. This was another document that was unsealed. Defendants reply to state's objection to defendant's order of proof regarding alternative perpetrators and defendant's evidence in support of offer of proof. You can go read this on the repository or our website at Justice for All. But basically, they were talking about there are thousands of tips. The state has chosen to present evidence in investigations into the specific named individuals, and the conclusion that the state has ruled out possible perpetrators. How did they rule them out? They just had the argument about DNA, that some people were not tested or obviously benchmarked. And he has the right, Kohberger, the defendant, has the right to confront the evidence. It's like they are pigeonholing him into taking a plea with the hopes of filing a PCR at a later date because he agreed no appeal. That would be a long process. And then they go on to say more redacted. More redacted. Who were these individuals? More redacted. More redacted. They point to the 4 perpetrators, which is still redacted. Then they sign it off. Okay. Now, who do you think could be those 4 perpetrators? 4 perpetrators. Who do you think that could possibly be? I mean, I do have my own speculations. They've given us all those names, but I'll tell you, these were names that were mentioned early on in the investigation. And in my humble opinion, it's been riddled in the documents we've been given with the ISP, even following these individuals into Boise. Yes, folks, following these individuals into Boise. The names aren't hidden in the documents. The individuals have been crossed out or redacted, their first initial, last name, initial, date of births, highly redacted in the ISP. But this whole filing was responding to the state's objection about whether the defense could bring up alternative perpetrators. You know, other people who may have committed the murders. In the core of the issue, the state prosecutors, they didn't want the defense to present evidence suggesting that any other named individuals could have been involved. And the defense argued they have the constitutional right to show this evidence because Kohberger is entitled to a complete defense. I'll be going over this at 3:45 today. Join me if you're free. If not, listen to the replay. I love my replay crew. I love you all. Be well.
No more hidden verdicts, no more secrets sold. Every voice is a weapon, every story be told. Innocent till proven guilty, that's our final decree. Under this constitution we stand forever free. Phoenix in the dawn, truth ignites the sky. Together we stand tall, no more asking why.